Good afternoon, Chairwoman Smith, Vice Chair Reynolds Jackson, and members of the committee. My name is Zach Doherty, and I'm testifying on behalf of the League of Women Voters of New Jersey. We are here today to oppose Bill A4045. As a community organizer, I want to share my firsthand experience engaging with the public, your constituents, over the recent months. Their collective outrage towards this bill has been palpable and resounding. Despite efforts to amend this legislation, this bill continues to create unnecessary barriers and obstacles to accessing the public records. In addition, our members and the public have not been given adequate time to review the proposed amendments and continue to express significant concerns with the direction of our democracy in New Jersey. To use the analogy, where there's smoke, there's fire, the same is true of this legislation. Where there's legislating in the dark, there's likely a flawed bill lurking in the shadows. The amendments fail to address the League of Women Voters of New Jersey's core concerns regarding this legislation. There are too many components of this bill that make it harder for the public to access public records. One of the areas that is most troubling to us and to many of our partners is the guts to fee shifting. We've made it clear that fee shifting needs to stay intact for the protection of New Jersey's Open Public Records Act. Without fee shifting, regular members of the public will not be able to access legal representation when records are improperly denied, which we know happens frequently. We will not support a bill that erodes the public access in this way. This bill creates additional and unnecessary hurdles for the public, including putting the burden on the public to prove a fee from an agency is unreasonable, prohibiting the public from requesting records from multiple agencies, and asking for different levels in request. What is worse is the public continues to face vague and unclear threats of lawsuits, and ultimately members of the public will be less likely to request the public records they are entitled to, and if they do not make requests and are wrongfully denied, they have less ability to pursue legal action. This bill also does not accomplish its stated purpose of modernizing the Open Public Records Act. It falls short of introducing changes that would help improve OPRA and make it more efficient to access records, to help understand government activity, and to hold government accountable. Instead, this legislation creates significant, unnecessary hurdles. League members want an active, engaged democracy that works for the people. The legislature should be moving forward on good government issues by increasing transparency instead of making it more difficult for the public to be civically engaged. I urge you to stand up for democracy and vote no. Thank you.
Thank you. Next.
Good afternoon, Chairwoman Swain and members of the committee. My name is Janie Bennett, and I'm testifying on behalf of the Morris Area League of Women Voters. Our league spans numerous municipalities in Morris County, including in legislative districts 21 and 25. The Morris Area League is also strongly opposed to Bill A4045, which is before you today. I do want to avoid repetition. I'm not going to say the same thing as my colleague, but suffice it to say that the Morris Area League agrees fully with the positions stated on behalf of the State League, as well as in prior hearings, the ACLU and our other pro-democracy partners. We strongly believe this bill is designed to both deter and impede the public's ability to obtain government records. But I want to focus on and highlight one specific provision that, even after slight amendments to it, I believe contains a loophole that's arguably large enough to make it impossible for any requester to obtain almost any type of written communication that's supposed to be generally accessible without facing likely litigation costs. The provision states as follows. A custodian shall not be required to complete a request, including for, but not limited to, mail, email, text messages, correspondence, or social media postings and messages, if the request does not identify a specific job title or accounts to be searched, a specific subject matter, and is not confined to a reasonable time period, or if the custodian determines that the request would require research and the collection of information from the contents of government records and the creation of new government records, setting forth that research and information. Now, the problem with this is, if a requester is mandated to ask for only communications that are narrowly tailored to specific subject matter, specific title account, and specific time frame, then by definition, the person complying with that request needs to do research to collect that narrowly tailored information from documents that don't automatically tailor information in that way. So they're going to have to, in every case, research existing documents to cull out the mandatorily narrowed requested information and create a new document that provides that. So you're in a requester is in a catch-22. I make my request too broad, it's denied because it's not mandatorily limited. And if I limit it the way it's supposed to be, It's denied because now somebody else needs to do the research. The custodian needs to do the research to call out that narrow request. I think it's a disastrous provision that will only lead to litigation. And in addition, some of the standards within it are overly vague. Like, what is a reasonable time frame? What is a limited subject matter? For that reason alone, although that's clearly not the only reason, I very much object to this bill. I think it is destined to create endless litigation and impede access to government records, and I ask you to stop it today. Thank you.
Thank you for your testimony.
Good afternoon, committee members. I'm Evelyn Murphy, co-president of the League of Women Voters of Monmouth County. I'm here today at the request of my board of directors, representing 320 Monmouth and Ocean County members living in legislative districts 9, 10, 11, 12, 13, and 30, who remain vehemently opposed to the attempts to roll back the Open Public Records Act, gutting important provisions that we rely on every day as League members. The amendments to the bill were unofficially released through the press just this week. This disregarded our calls for more time for the public to properly evaluate the contents of the legislation. Even with limited time to review the amendments, however, we can see that many problematic provisions remain, sort of wolves in sheep clothing. You changed the language, but you did not address the core issues. Specifically, changes to the fee shifting, as we've heard, still make it difficult for the public to be able to find legal representation. Changes to the harassment provisions still enable the public to be sued for vague and unclear reasons. These provisions are already hampering us because when we need to ask for things from local municipalities, we're already censoring ourselves. Are we asking it in the right way? Is someone going to be denying us under this law that's being proposed? And so do I dare submit a request on behalf of the League of Women Voters, which might then lose its authority to request documents at all? Or do I say, well, I'm old enough, so I probably am not going to do this much longer. I do it as a person instead of as a league. Those are things that are occupying our minds already. And with this change, it's going to really have a detrimental effect on our ability to represent voters. And then it still remains difficult under the provisions of this bill, as Janie has indicated, for people to access the records they need. So I'm here to please ask you to listen to the voters and vote no on this bill once and for all.
Thank you for your testimony.
Chairwoman, I just have a quick question. So your testimony is that asking for having a very specific topic as well as asking for a very specific time frame is unreasonable?
I think the part of that provision that's the most concerning to me is the sentence after, which says that a custodian of records can then reject the request because it requires research and the collection of documents. So it seems like the provision is trying to do two things that are mutually exclusive. They ask for a very specific manner, but records aren't created in that kind of manner. You don't create emails that only address one narrow subject, or you don't only address a subject in a certain time period. So to get the right information responsive to the request, now instead of the journalist who gets a mess load of emails to do the research and find what's important, the custodian of records has to do that research. But under this rule, if the custodian of records has to do that research, they can say, I don't need to comply with this because it requires me to do research. So I'm not completely opposed to some limitation on the means that the request has to be made. You can't just say, I want every email, every written, on every topic forever, but you can do a reasonable time frame and a reasonable limitation And then the custodian has to do their job and find those documents and give it, not say, well, that means I need to look through them and see, does this email address this? Oh, only page one of it does. Now I'm creating new documents, I'm doing research. I don't have to do that under this rule. Go away. That's the problem I have. Thank you.
Thank you. Assemblyman Law.
Thank you, Chairwoman. Thank you for your testimony. I'm kind of looking at this where we're sitting here trying to make adjustments to this bill so that it's more palatable to you. And that's one way to look at it. I'm kind of looking at it like, why don't we keep the bill in force and just make certain changes, moderate changes to it that will just address the couple issues that aren't working properly and leave the rest of it intact. So, maybe I'm a contrarian, but it seems to me that we should be looking at it that way. Now, I spoke with several of my colleagues before this meeting, and one of my colleagues mentioned to me an issue that I was hoping you might be able to help me figure out. My constituents always know more than I do. The colleague said to me, he was a former mayor, he said that we had gadflies who come in that basically harass the clerks with on and on and on every single day, with every hour, with more open requests. And somebody asked for something, they printed out 900 pages, and he came and took it and dumped it in the garbage, right in front of the clerk, just to poke him in the eye. So these types of things are concerns for municipalities. Municipalities that are small. One of my other colleagues said, well, the entire municipality is 2,500 people. They can't afford to cover all these costs. It goes into the hundreds of thousands of dollars. So help me to support you. How do we address some of these things? What would your ideas be to amend the bill to address this, and then, or just put the bill aside and come in with another piece of legislation that would address those things and leave OPRA intact? What would your answer be to me and my colleagues here? Because we're all searching for something, because I think many of us are vexed on this committee today about how we're going to vote.
I think the first step of that would be to not be rushing this process. And the fact that we're here on a Friday, which is uncharacteristic to be debating this for one particular bill. But I think you make a reasonable point that there is room for improvement, and those conversations have to happen and need to continue to happen. And for the overhaul, for something this large to be happening so fast, and I understand that there's been work for at least a year on trying to get this, and there's been multiple introductions of this bill, but it's just disingenuous for any assumption for it to be that we've gotten to this point because the public has been engaged and absolutely on the same page with the sponsors. It's just not that true. There's still a great debate to be had. And I think to speak to your point about arbitrary OPRA requests and files, I think Senator Weinberg puts it best. When the public are annoying, that's what they do. Whether we like it or not, you're a public servant. Officers of agencies and administrations are public servants, and it's not our place if something seems arbitrary. If it's within their right under the law, it's the public are annoying for a reason. And sometimes that annoyance or that nuisance is to make sure that we're doing what we're supposed to do as a government.
If I could just add one thing, I do agree with the approach of leave OPRA intact and try to figure out what the most vexing issues are and address them in narrower forms of legislation that need to be worked on, again, not on a Friday afternoon in front of a mic on the spot. However, I will say I previously practiced in family law, and there were issues of repeat offender litigants who would just come to court filing frivolous motions after frivolous motions after frivolous motions. It happens in every area of the law, some more than others, and it is vexing and it is a problem. But they didn't write legislation that said you can no longer have the right to go to court over these issues. You can be thrown out. What they did was take it on a case-by-case basis. So if a judge saw a repeat offender over a long enough period of time, they could put in place remedies that address just that person. So I'm envisioning, and again, on the spot, I don't know exactly what the language would be, but there could be a way where if a person has gone to court repeatedly, they've been denied records because it is overly burdensome or some way that it would be drafted, and there's a repeat offender kind of provision where judges might have discretion to deal with that issue on a one-person basis, not changing the accessibility of government records to the entire public. So it would take some thought to figure out exactly how to write that, and that's what needs to be done. Take some thought.
Thank you.
So, through you, the chairwoman, just one.
I was just going to suggest perhaps you meet with the sponsor of the bill. If you you have some questions or suggestions. Did you have any other questions?
No, that's fine. I'll take your counsel on that. Thank you.